No, thank you all very much for coming to this presentation. I appreciate it. I know it's 3:30 in the afternoon. We're going to get into financial investigations. Kind of a tough sell. Are those? Can we lock those? Mike, do you mind locking those doors? Lock them up. Bolt them. Mike Giardino, thank you very much for coming. He's on his way out. So I very much appreciate being here today. It's an honor to be speaking at this conference, and I appreciate the members of my office being here to support me. Jeremy, Shannon. I'll run through everybody's name, and that'll get us to 4:30. But no, I'm going to talk to you about financial investigations today. I can't remember when I was last here. I'm sure you all do. It was on arsons. Now I'm talking about finances. Two things that I never thought that I'd be prosecuting, let alone giving a talk on. Part of my interest in financial investigations is my memories from district court. And I think I was down there in district court for about 6 years. And anytime a case came across, I don't even know if I had a desk. I think I was in broom closet for a period of time in Wareham District Court. But anytime one of those cases came across my desk, I just had to get away from it as quickly as possible. Just terrified, it's civil, it's not really a criminal thing. Tried to resolve it just on, restitution in court, just anything to resolve it as quickly as possible. And I'm haunted by that. Haunted. I don't sleep. So part of my interest in it was just to say, can these really be that complicated? And the answer is that they're not. With a lot of these cases, with a lot of cases that I do, and I'm sure that you've done, you kind of know what happened. You know that something happened, but sometimes you leave a case, even if it's post-trial, and you're like, it's somewhere in the middle. The person's still guilty. They still should have been convicted, but there's something that's always going to be a mystery. With financial cases, every step, every method is documented, and you can truly just create a complete story of what exactly happened, leaving no doubt for yourself, no doubt for the jury, no doubt for the court, and it can just it changes how you go into court when there's no mystery whatsoever as far as exactly what happened. So this is Follow the Money, Prosecuting Financial Crimes, a case study in methodical digital investigation. I guess I could speed this up. All right, so this is slide number 2 of 67. I sent this to the MDAA, Jessica Stone, yesterday, my slide presentation, about 11 o'clock at night. And she emailed me back immediately and said, "Are you sure about slide number 2?" Which is not, I don't need to hear that. But so if there's reviews, if you have a chance to fill out any critiques, if you could please highlight slide number 2, and let's just show her they didn't make a horrible mistake. But all right, so this slide number 2, is court orders. I'm presenting this as if everybody's in Superior Court. And so I looked at this from the perspective of going into grand jury. And there, I'm not sure how many people do it. I love to do it, but it's not a standard grand jury subpoena. Instead, you fill out, it is like a subpoena, but at the same time, you fill out an affidavit, a small memorandum of law explaining why the court can act on it. And then you also, depending on the judge, you also create the proposed court order yourself. And then the judge typically, and I usually put this in my affidavit and memorandum, just can you please review this and act on it administratively, so nobody has to come into court. You file with the clerk's office, and it's typically almost always handled administratively, and I've never had any rejected whatsoever. And so, again, I put this together looking at it from the perspective of Superior Court, but you can also take this information and apply it to Rule 17s if you're down in District Court. And I've done this for internet providers, and I'll go into this a little bit more detail through a specific case, which I think is slide number 3, not to spoil anything. But juvenile records, electronic storage services, DCF, Mass Department of Transportation records, and rehabilitation records, all through the grand jury, all through court orders. All right, so I've been to a lot of these presentations, and I've tried to give one, or I didn't try, I think I succeeded. I gave one on arson, and I tried, my goal with these presentations is to try to make it as practical as possible, hopefully interesting, so I'll use a specific case. This case was a couple years back. It was prosecuted by myself in Superior Court. Essentially, the victim in the case was about 22 years old. He was autistic, and he was severely autistic, and he was working at a Home Depot store down in Plymouth, and didn't have many friends. And the defendant was a coworker. He had no prior record. He was active in the military. The Home Depot job for him was just on the weekends. And the victim in the case thought of him as like a really good friend, close friend, and just wanted to be his friend. And so the defendant would constantly pick on him. He didn't realize it, but the defendant picked on him, kind of bullied him around. Other coworkers said that he made fun of the victim behind his back, things like that. But at some point, after about 2 years of working together, the defendant approaches the victim in this case, and I'm trying not to use full names. The case has resolved, but I feel like at this point, it's like the JFK files. We can't say anything until everybody's dead. But the victim was invited by the defendant to join a fantasy football league run by Yahoo, and it was like a $50 buy-in. The defendant sold it as being fun. You should join up. You'll probably win. And the victim was really excited and paid the $50 and joined in the football league, which was called Fantasy Flight League. I know nothing about football, Yahoo, any of those things, but which will go into how I struggled with this case, but essentially starts off fairly normal. The league is going on. People are throwing footballs around. They're scoring touchdowns, things like that. But eventually, the Yahoo Fantasy Flight has a group chat where people can post, basically on a wall where everybody can see it. It's public to everybody in the league. And very quickly, the members on the league, start issuing threats to the victim, saying that they're going to show up at work and they're going to beat him up. They're going to come to his address. They start pestering him like, you should be afraid. This goes on for about 2 or 3 weeks. The messages are getting worse and worse. And one of the main drivers was, his name was Shark Tank in a league. The defendant said that this was one of his good friends from the Otis Air Force Base where he was stationed, and that he had met this Jesse Connington in the SCIF department, which is like a high security wing at the military base. The defendant never steps in, even though he's posing as the victim's friend, and like tells them to stop harassing him. At one point, there's messages with the victim saying, "Can you please do something? You're the commissioner." And the defendant's like, "That's not my role," which arguably makes him a worse commissioner than Roger Goodell, but that's up for debate. And so this goes on. The threats keep escalating. I mean, there's some examples. There's at the top right, it's, I need some money. I'm going to come to the depot and punch face and take his register. The threats also consist of some of the members saying, like, we know when you work and we're going to steal, a bunch of stuff while you're working and somehow pin it on you. And again, this goes on, and eventually the defendant in the case reaches out on the side, both through like a private messenger on the Yahoo Fantasy Flight group league, as well as directly messaging him over Facebook, and basically, start saying like, this is bad. I mean, there you see one says, "Yes, we're fucked." He's like, "I don't know what we're gonna do. I really think these guys are serious." And so the defendant proposes, maybe if we offer these guys, specifically Jesse Connington, his friend from the Air Force, if we offer them some money, maybe they'll agree to leave you alone. And I think it's it's hard to see, but the victim goes along with this and is like, well, what do you think it'll take? And throws out like $100. And the defendant's like, it's going to take a lot more than that. I think he says $4,000, something like that. And the victim is thankful, says, yeah, you know what, I'll do this. Let's pay them off. I'm really scared. So yeah, so the defendant basically says, listen, you're my friend. I don't want to see you get hurt. I'm going to use my own money from my own bank account, and I'm going to meet with these guys, Jesse Connington and the others, and I'm going to pay them and make sure that they promise to not hurt you. And he goes as far as meeting them in the dead of night in a deserted parking lot. Very dramatic. And says, I put the money in an envelope and I passed it over. He was in a big truck, and he agreed that he'll tell the guys to not hurt you. And so he reports this back, and he has the victim transfer him money on Venmo and PayPal. Unfortunately, the defendant keeps coming back because the messages on the Fantasy Flight group chat, they go into a lull for 3 or 4 days. The messages stop, but they pick right back up. And the defendant says, you know what, they want more money. They need more money. And he says, I think you should agree to it or you're going to get hurt. So again, he keeps just selling this, that he's meeting with them, he's handing over his own money. Then he reports back to the victim and has him transfer PayPal and Venmo payments directly to him. And the defendant also plays up listen, this is draining my bank account. I'm almost out of money, just trying to keep you safe. Can you try to get me the funds as quickly as possible? This goes on to the point where the victim ends up transferring him $24,000. Before this, he had never really transferred. This is all in 5 weeks, but he had never really transferred any significant money on either platform. And one of them, I believe it was PayPal, actually blocked him. So there's text messages where the defendant's instructing him, get on Venmo. They don't have a limit. So he hands over $24,000. So again, I think I jumped the gun, but my point is I didn't understand anything about Yahoo. I didn't understand anything about fantasy football, or real football for that matter. I was like, well, one of the things, and I think you'd all agree from just hearing the facts, it's a little suspicious that the commissioner of the league isn't telling any of these other players, because I think it's a click of a button, you can just boot somebody out, and they're banished from the league. Didn't do anything. So I wonder if he's controlling not just Jesse Connington, but the other players on the league too. I think there was about 10 in total. And so get this case, mark it up for a grand jury investigation, and the first thing I do is get a court order, and these are just the USC statutes that I cited in my court order, but basically Yahoo, I want IP addresses, I want all the subscriber information, any linked email accounts, any linked phone numbers. In the event that somebody gets locked out, you need to provide a phone number for password purposes. I want all of that, so got a court order for every single member in the Fantasy Flight League, all their subscriber registration information and linked devices. So finally get the court order sent, and this took a very long time because according to the woman that I spoke to that works at Yahoo, I believe her name is Maria Abuza, she had never gotten a request dealing with the fantasy league before. So I think it took about 3 months, but ultimately they send a response, and the defendant is at the top there, some crazy Sox fan at yahoo.com, and you can see there's many of the players in the league. Each of these rows is in regards to a player. He was controlling, he created more than half of the players, which explains the trade of Christian McCaffrey and Tyreek Hill and Travis Kelce for Cam Akers and Russell Wilson. I Googled that last night to make that joke. And just going to pause here for a second as far as, I know a lot of prosecutors, not a lot, but I know that we have authority and we're supposed to have the answer to everything and it's a court order and all of this. I'm just going to pause here for a second as far as if you're reaching out, if it's a Rule 17, which this could have also been done with the Rule 17. You could also cite the same USC statutes in the Rule 17. Even though that's a court order, you can, I think Yahoo and other services like that look for terminology. In the end, it's a court order. They have to comply. But I would say, as I did with Yahoo, as I do anytime I deal with a bank for the first time, anytime I deal with any records that I'm unsure of, if they comply, if they're helpful, if they're getting back to me, I then, and this is maybe common sense, but I go on Google and I type in who is in charge of whatever department they're in, and then I email that person, CC them, and say, I just wanted to let you know that this person was very helpful, answered my questions, and was a great asset as far as what I needed. And that then, they appreciate that, I'm sure, but also you have a good point person the next time you need records from that same institution. But yeah, so he's controlling the league over 50%. Again, that's just the USC statutes that allow us to get records from Yahoo and other internet providers. The next step was the defendant had said, this is my good friend Jesse Connington. I met him in the SCIF department. We go to the gym all the time. Really good guy. One of my best friends. So the next step after seeing that he controls the league is, well, does Jesse Connington, does he even exist? Or is this just a made-up person, this bully, somebody that the defendant made up to create the impression of threats? So the next court order, and again, this could be done through a grand jury, it could be done through a Rule 17 as well, but requested records from the 102nd Intelligent Wing at the Otis Air National Guard base down in Cape Cod, I believe. And so the order that was sent to the base was for, first off, an affidavit saying whether or not Jesse Connington exists, if he's an active member down there, or if he ever was enrolled in any position down there, and more specifically, the SCIF department. It's a high security department. Somebody that's going to be granted that access would have to go through a deep background check. There's applications, documents would be provided. So in the event that he is real and he did work down there, we want all of that. And also the defendant, he said that he met the Jesse Connington in that department specifically. So the court order also requested, can the defendant get into the SCIF department? Is this even realistic, what he's saying, how he met the defendant? And also, he had specifically said that he knew him from working out at the gym, so found out I talked to somebody down there before I sent the court order. Another good thing to do, reach out to the company or the record holder beforehand and say, what can you give me and what can't you give me and what would you need? But to get into the gym, everybody has to swipe. They get a card, so all right, it might be overkill, but did the defendant, can we get his swipes for whatever the time frame was of this investigation? And sure enough, records come back. Jesse Connington never existed, or at least he never was at that military base. They had no record of him. And the defendant never went to the gym. So yeah, he lacked the clearance needed to meet his friend, and gym data showed that there was no evidence of his high-intensity workouts with Jesse Connington. Can I just pause for a second? Jeremy, is it all right if I pause? I know that this is on financial investigations, but I will say also, and God, sometimes I'm overkill with the investigations, but you can take the specifics here and you can also apply them to cases across the board. It makes you, I don't know, it changes you. It makes you look at things a lot closer, because the corroboration or negating something that the defendant or somebody else said, if something's done at this point, in this day and age, there's going to be a record of it. And so just for an example, I had a horrible sexual assault. The defendant was the father of the defendant was the victim's father, and she had disclosed to her mother late at night that the defendant had sexually assaulted her for close to a half a decade. The facts were horrible, and the mother, after she learns this, the defendant is at home with their son. And so they drive home, and she goes berserk, the victim's mother, and throws him out of the house. And they don't know where he goes after that. And then, this was some time ago, but there was an indication that he had tried to get a flight to Cape Verde. And so, again, just using the USC statute that I mentioned, I sent a court order to Homeland Security, and I didn't know if they'd respond. I didn't know if they'd receive the court order, but they did, and they sent and it's cut off, but on the right there, they sent a log of every ticket that he had purchased. There ended up being some sort of crisis, not in Cape Verde, but along the route of travel he was taking. So his flight had to be rescheduled twice. So they provided a breakdown of every attempt or every ticket that he bought and then rescheduled, and also provided records showing that he had never, or not never, but he had not left the country or attempted to leave the country 20 years prior to this offense. So again, that's just an example of how you can use court orders and these statutes to get information. All right, so we have Jesse Connington doesn't exist, or he never worked at, does he? Or he never worked at the military base. We also have the defendant controlling the entire Fantasy Flight League for the most part. Obviously, the next step, maybe it should have been the first step, is, well, let's confirm for larceny purposes that the defendant actually took the money and that the victim parted with the money. And so that was fairly simple. The victim provided his Venmo and PayPal transactions. It's on the right, just a few of them. And so that was, you go on to that just standard subpoena. Again, you could just use a Rule 17 if you have a larceny case in district court, and just sent those to PayPal and Venmo, and they're great. They're very responsive compared to others. They take about 2 weeks, and they get you everything. So we get that. We've confirmed that the defendant did, in fact, transfer money over to this, or the victim transferred money over to the victim multiple times, reaching $24,000. Then from there, sent subpoenas, again, just a standard subpoena to the defendant's bank, because just to show, all right, he took the money, he received it, but does he still have it? Was he spending it? And he was also, repeatedly, again, it's about corroboration. You have the defendant's statement saying, man, my bank account's running low, you're really draining me, I'm just trying to protect you. So subpoena goes to the banks, and those show that the defendant's accounts at two different banks, they didn't decrease at all during this time frame. In fact, they increased because the victim was giving him money. Right, it says his balance stayed above $10,000 to $12,000 throughout, which then you can take and compare it to his text messages saying, I'm almost broke, I don't know what to do, help me out. This is the last part of this case, not the presentation. We're only about 1/10 of the way through. This is just a nice little kicker. So the victim eventually never told his parents about this until he hit the $24,000 amount. Tells his parents are like, what the, we got to go report this to the police. So they go to the Plymouth police, and the victim at that point, he has trouble communicating, but he gives the officers enough information, including the PayPal and Venmo printouts. And 2 days after this short interview with the victim, Plymouth police on the general business line get a message left around 5 in the morning, and it's from the person who introduces themselves as Jesse Connington and says, hello, officers. This is Jesse Connington. I understand that you've been looking for me. The voice is very robotic, stilted, almost mechanical. Hopefully that those words don't end up on my critiques of this presentation. And he says, I just want to confirm that the defendant did in fact give me 2 payments of money to leave the victim alone. And then there's a long pause, and he says, well, I hope this clears everything up. I'm sure you won't need to speak to me again, and hangs up the phone. So I'm not a detective, but that's also sus, right? Reasonable sus. So there's enough built at this point to, I think, understand what happened, but I was haunted by, for the love of God, in this day and age, somebody's leaving a call with the police, we should be able to figure out who did this, right? Right? I Google, how does one leave a message as a robot and block number? And the very first result that came up was this spoofedcall.com, which I think is used by telemarketers. I was like, all right, well, I'll take a shot in the dark, and I sent an email to the spoofed card. The website, it wasn't legal, because those are hard to find when you're trying to get in contact with somebody. It was just to the information, general email, hey, I'm a prosecutor from Plymouth County, and I'm just wondering, do you track if people use your services, and how, what sort of information would you need? And what they needed was the number, because it's not a block number, it comes up as a different number. And here, it came up to a woman's house down in Hyannis who did not know Jesse Connington, nor was Jesse Connington. Would you need the number that the call comes from, along with the exact time that the person received the call? And thankfully, Plymouth Police had saved the call log from that call, so we had the specific time, and that also had the number that the message from Jesse Connington came from. So, general subpoena, again, you could just use a Rule 17 if you're in district court. Sent it to spoofedcall.com, and they confirmed that it came from the defendant's, they didn't confirm it came from his number, but they confirmed that the defendant had registered an account with spoofed.com on the same day. He registered for the service at the same time that the call was received from Plymouth, or 10 minutes before the call was received from Plymouth. And they couldn't confirm that he actually dialed the number. I forget why. There was an issue with the call logs. But yeah, and then this is just additional corroboration with this specific case. We had the Facebook messages back and forth between the defendant and victim. Again, maybe overkill, but at the same time, you know how tricky courts are if it goes to trial, getting records in. Nobody stipulates to anything. General subpoena, again, could be a Rule 17 to Facebook just for the subscriber registration information for the defendant, for the victim. Got those back, showed that and there was really no question, but that they controlled both those accounts. It could be tied to those messages. The Comcast subpoena was sent in regards to the spoofedcall.com. Got the IP address. They didn't send any information along with the IP login for when he registered, except for the address itself. Going on to Google, just punched in the address. For location purposes, I've found that IP addresses are a disaster if you try to just use a general service. But as far as the provider of the IP address, they're pretty dang reliable. So it said it was with Comcast, so you get the IP address. You also need the exact time that the IP address was used, which will almost always be included with whatever records you're getting with IP addresses. But if they don't have that, they can't find it. But here, the IP address with the spoofed card was linked to an email address of the defendant's parents. And like I said at the beginning, or towards the beginning, just again, every step that somebody takes, regardless of the type of case, it's going to leave a trace. Something can be found, be it through Rule 17s or grand jury subpoenas, court orders. You're going to get something. There's always a trail. Yeah, again, just this was all put together with minimal police involvement, just general subpoenas to PayPal, Venmo, like I said. Comcast, that was a general subpoena. Facebook, Yahoo. If you're just looking for subscriber information, registration information, basic billing information, it's just a subpoena or a Rule 17. As far as the other things, those just required reliance on USC statutes. And so the outcome, defendant was indicted, and he very quickly admitted guilt. He returned the $24,000 that was taken, and yeah, the entire case was just built up via the grand jury. No search warrants were used for any of the records. The defendant received, along with the full restitution payment that was made on the date that he pled, it was guilty probation for 3 years on larceny. And a lot, I come back and people are like, you did a lot of work here, just guilty probation. Again, going back to what I said at the beginning, but the fear and the guilt that I feel about running away from financial cases, I don't understand it that well. But with every case, I try to dive in and I try to understand it, because in the end, I think of it as like, well, if I can understand it, then that gives hope to explaining this to the jury if it ever gets to that point. But I also do it because, and maybe I'm wrong, but at least in my experience, it was quite some time ago, but when these cases were down in district court, I don't know what happened to them. I imagine a lot of them, not because of me, I am being recorded, but I imagine a lot of them end up getting dismissed. There's pretrial probation, restitution paid, and then the case gets dismissed. I did not see a lot go to trial, and I saw a lot get just let go, more or less. So I kind of do this too, because I think of it as like, well, this case may not exist if we don't do an investigation here. So yeah, guilty probation is not the harshest sentence, but it could have been nothing. The defendant could have gotten away with it, and the victim would have been out $24,000. So to me, the victim didn't want to testify. Again, I told you about his mental health issues. He was also scared to see the defendant. To me, this was a victory, and I was really, really proud of the outcome. It's just about creating a trail, knowing exactly what happened. So a great resource, I don't know if this is common knowledge, I'm sorry if it is, but is the ISP list. What I do is I go onto Google and I type in ISP law enforcement, and it'll be the first result. But it is the greatest website as far as figuring out who to send a subpoena to, who to send a Rule 17 through. The site, depending on, there's probably about, 3,000 entities listed on there. Each one has a breakdown. Some are more detailed than others, but it'll tell you what information you need. And specifically, like, we can give you this information with the subpoena, we can give you this information with the court order, and we can give you this information with the search warrant. So you can frame whatever your method is in requesting this using that website. It also gives you contact information, because again, the amount of time wasted trying to find a point person at some of these companies is it's astronomical. So can't recommend it enough. Great resource. This gets a little bit more specific, but as far as requesting financial documents from banks, I'm not going to break this all down, but these are just some of the requests that I would include in a Rule 17 or a grand jury subpoena. Most of them are fairly obvious. You want the signature card to show who controls it, who could have access to the account. Typically, it's only one person, which will help your case. The two things that I'll highlight here is the internal notes or compliance alerts. I always throw that in at the end as far as any internal emails sent between tellers or managers regarding the specific account or accounts that you're requesting, because you could get emails from the suspect or defendant. You could get recorded calls sometimes between the bank and the suspect, which, I say notes there, but I would change it to communication. And you also typically have, depending on the case, obviously, you have the victim coming in and reporting it to the bank. So you have another additional witness there as well to, potentially, depending on the case, break down their reaction, their emotional state, what they reported, all of that. Checks, God, this is getting really basic, but I'd request the front and back, because banks sometimes love to just send as little as possible. I learned this from Assistant District Attorney Burr in Norfolk. I can't think of a specific example, but I would get I would get responses back from banks, and there'd be an example of like, I know this transfer happened. Be it the victim provided a photocopied statement, something like that, but there wouldn't be a corresponding check. And ADA Burr, they told me to change it to monetary instruments or negotiable instruments because, again, banks sometimes shortcut you, and that'll ensure you get anything, any type of money order, check, cashier check, anything that's withdrawing or depositing money into the bank. And that's truly, I'm not trying to be funny, that's truly been a game changer. It's gotten me so much additional information on cases, investigations. Again, it might be a little bit basic, but I also, with any request to the bank, I always request the debit card that is linked to the account at the time frame that you're investigating or that's part of your case if you're in district court. The purposes for that is that if you send a subpoena or a Rule 17 to a store where the defendant appears to make a purchase, and if you're looking to see if they forged a signature or for whatever reason, you're just looking to confirm that the purchase happened, if you send the store every piece of information you know about them, I mean, Social Security, the bank account, everything you know about the defendant, the store can't do anything with it unless you give them the last, I think it's 4 numbers of the debit card, along with the expiration date. With that, the store can easily pull up, usually in seconds, they're usually ecstatic to help, they can pull up any transaction that you're looking for. But without that debit card, you're left with just the bank record showing that there was a purchase there. But with this, you can get itemized receipts and potentially forged signatures, things of that nature. And it'll tell you exactly what was purchased, when, and where. This is just another suggestion, great resource. Has anybody here used FinCEN for any? It's great. Man, reading those records, though, is like, it's tricky sometimes. But no, FinCEN, and I'm not going to go into this too much. Fusion, this is the contact information. Just reach out to them. This I found, again, the records are really tricky to read, but if you're starting from scratch and there's been money taken and you have absolutely no idea where the defendant may hold a bank account out, like you have nothing, no information, you can send a request to FinCEN, and there's a pretty epic form, and it's always changing. There's always new law, but they have you fill it out. You basically, and this is not a joke, you swear your life away that you'll never disclose that you've reached out to FinCEN, but they'll send you reports anytime that there's been a triggering of a CTR where somebody has deposited more than $10,000 into a bank or withdrawn $10,000 in a bank. And they'll, usually they don't contain, they'll also potentially contain SARs if the bank has their own suspicions of activity going on. The FinCEN records, if a CTR was triggered, they're going to give you a bank account, and you can follow up either via Rule 17 or a grand jury subpoena. Specifically with district court, this is just done via email. There's no court involvement in this, so this would be like a stepping stone to get to the point where you could then, fill out and submit a Rule 17 with district court to get the bank information. The SARs, those, again, sometimes they're very tricky to read, but those can just be requested. When you get the FinCEN records, if a SARs has been triggered, it'll be listed somewhere in those reports, and it'll give you an email contact to reach out to, and they'll give you the specific SARs documentation to request. And again, there's a couple banks that are a little tricky with it, but for the most part, I read it as, it's just an informal email. There's no court involvement, and there's no subpoena needed. You just request it via email, and they should comply. But FinCEN's great. Definitely suggest reaching out to them. I didn't ask them if I could put their contact down here, but they are always excited. They're always saying, like, spread the word, so I'm sure they'd appreciate this. Super helpful. And, again, a lot of these records are in a different language. They love follow-up questions. They'll break things down for you. They're fantastic. A credit check. Again, this is a step one can take either via a Rule 17 or a court order if you're in the Superior Court and doing a grand jury investigation. But essentially, you get the court's permission to run a credit check on the suspect or defendant. There's 3 listed because usually, 1 out of the 3 respond. It's mostly the same information, just in a different format, but I do all three just because they're not the most responsive sometimes. But there, you'll get that back. It's pretty quick again, probably about 2 weeks. It'll tell you any lines of credit that the person has open, and that's another way to hopefully establish where they might have a banking account at, because through those sources, you might find a linked bank account. It's all about building to that bank account for the most part. Tax returns, again, another resource. I'm sorry if this is common knowledge. It wasn't to me until about 2 years ago. Again, this is the person from the Department of Revenue, John Hayes. Great. Again, like Finson, very helpful. We'll do follow-ups. He's actually met with me in person to talk to me like I'm a 5-year-old and break things down for me. Fantastic. But there, again, this is constantly changing, but this is informal. There's no court involvement. You just email him, and then you'll get a form that you fill out that's included here, basically just requesting the tax returns for whatever years you're interested in. You do need to provide a basis to request the information. Specifically, there's tax evasion, they've omitted things on their taxes, something of that nature. But again, that can be incredibly useful because for the most part, I imagine if somebody has committed a crime or a theft, they probably haven't declared the money that they've received as part of their taxes. So you might find yourself with an additional charge. And as far as putting that in the request, it doesn't take much. Simply something like that will get the request fulfilled. They're great. It's usually about 5 days. They'll have all the information to you. Casino records. I think, this is relatively new to me, but I think it would require a Rule 17 or a subpoena. But if you use the correct terminology, each of these casinos in Massachusetts has a specific rewards card. They're broken down there, but for example, Encore has the Win Rewards. You can request anytime somebody's used one of their rewards cards at the casino, and that will break down the amount of money they put in when they came in and the amount of money they left with when they left. It'll also tell you how long they spent at specific games. They break it down by tables. They break it down by slots. Again, a great resource, and it's pretty easy, unlike some of these records, it's pretty easy to read. It's fantastic in a lot of these cases where it doesn't hurt to show, not only did they take the money, but they're burning the money. It's a great resource. With those, I don't have the contact information, but I just Google who is legal counsel for each casino, and their names are the first to pop up, and just email them directly. These are just, again, moving back to more general suggestions. Look, the ability to corroborate is in every document that you receive, if you look at it closely. And there's 2 examples here. One, I had a contracting fraud case. This was years ago, but it was in Middleborough. There was a retirement community in Middleborough where this roofer, in quotes, went around and said that there had been a bad, it was the nor'easter, and a bunch of the roofs had been torn up, and he had said that he would cut them a deal, and he just needed, $3,000 up front. He went to, I think, like 67 houses in one night, and took $2,000 from each of the homes, and then never showed back up. All of this is in quotes, but the contract that he used to, that he had the customers sign, it had in the top right corner, it had a Pink Panther logo. Again, using Google, I saw that it was linked to Owens Corning, and it said underneath it that he was a certified roofer. So there, I think this was still in district court when this happened, there was a Rule 17 just to Owens Corning. Is this guy actually certified? Do you have any relationship with him whatsoever? And obviously their response to the Rule 17 was, who? Who is this guy? So that helped with the larceny by false pretense aspect. MassDOT, again, a court order can get you every time a license plate. They don't even need an easy pass, has gone underneath a gantry. Similar to, great. Again, just examples of things you can follow up on. This is a statute you can use either in a Rule 17 or a court order in a grand jury investigation to get rehab records. It's very tricky to get, but this statute allows it. Basically, you just have to show that the details of why you need this information, and I've done this a few times, but I've kept it confined to just admission and discharge dates. Nothing to do with the treatment itself, which I usually put on a letter accompanying the court order. And I also request a level of freedom, meaning can the person, like, are they on lockdown, or can they come and go as they want? But you just have to show that the reason for this request is greater than the importance of privacy. And given the case, that's often not hard to establish. This will be, I think this is the last slide. We did it, guys. We did it. 266-60B. My mind was blown by this statute. Barbara Isola is here. She runs the grand jury. Barbara, good to see you. I remember the first time I did this, it was like, whatever our indictment, whatever. I mean, respectfully, our indictment reads in a, perfectly, but, committed blah, blah, blah in Hanson, Plymouth County, and then there'd be a semicolon, and it'd be like, and in Middlesex, and in, I don't even, these towns I've never even heard of, I don't know if they even exist. And the question, rightfully so, is like, what are you doing? What's going on here? And I don't know how long the statutes existed. I don't know, but you can, with the 266 crime, basically a property offense, including arson, including larceny, if one offense happens in your county, and this is frequent with contracting cases, certainly with larceny. I mean, to be fair, it's really not hard to, it's not hard to find a common scheme with most of these property offenses. Somebody burned something there, and then they went and burned something there. It's pretty straightforward, but this allows you to indict cases anywhere in the state of Massachusetts if there's a common scheme. Specifically, 266-60B in criminal Rule of Procedure 9 allow venue where any part of the scheme occurred. And so for about 2 years now, I've taken cases that are all across the state. And God knows defense attorneys like to file motions to dismiss and all sorts of motions. I've never had any of my indictments that consist of offenses across the state ever challenged, which I don't, that's not saying anything about me, but the fact that it hasn't been brought up in court or attacked, I think we're on solid footing. So this can be a great resource, a great tactic to take. Specifically, and I'll wrap it up, that is the last slide, but think about it in like, if you're going to file a motion in limine at trial to have a victim come in and testify from the other county as a potential prior bad act or a subsequent bad act, you're now bringing the case, all of the case, to Plymouth County or wherever your county is, and you're saving everybody time from having to potentially testify 2, 3, 4 different times at the same trial. So I'm sure, and I know that victims involved in these cases appreciate it. Condense it, bring it into one court, and finish it quicker rather than let it go on forever. Additionally, depending on the case, when you have a larceny, and they're all bad, they all should be prosecuted, but when you have a larceny, especially up in Superior Court or in District Court, and you're getting up after somebody just stood up and was handling a homicide, sexual assault, horrible cases. It's easy for courts to ignore a larceny case, to not take them serious, to think they belong in district court, or the classic defense claim that this is civil, Your Honor. Here, when you have a case that's all over the state with 10, 20 victims, that's going to make you stand out more, and it's going to make your case a heck of a lot easier. So that statute's definitely a great resource, and I'd suggest looking into it. It's been great. I think that's it. I will now take any questions. But just if you ask a question, you have to sit at this table, because we haven't used these 2 microphones. And no, does anybody have any questions? I really appreciate everybody coming here. I will also say a lot, and I'm not Plymouth County. A lot of my coworkers are here. I love them, but they've also been great. My first assistant, Jack Zanini, and obviously DA Cruz. These cases are, and whoever's done, these are time consuming. It's really hard to balance on top of the other types of cases you have, depending on your office. And also, there's so many of these cases where, I was going through my share folder trying to think of something, anything to talk about today, and I'm looking at all the investigations that are just active, but I went down one too many rabbit holes, and ultimately something's overseas and probably not going to go anywhere. But my office, DA Cruz, My colleagues have been great in like understanding, like I'm not just sitting in my office and not doing anything. And you need support like that from your colleagues, from your DA, from everybody. But these crimes, I look at it this way, like not many people are taking a swing at them. Take the swing, because the victims will certainly appreciate it, and it's good work. So if anybody has any questions, I will take them. If anybody ever wants to reach out, I love talking about this stuff, not just financial crimes, but any case, trial strategy, please reach out. I'm always sending off emails to the entire state, every DA's office for questions, because we're the greatest resource. Your colleagues, fellow ADAs, like we need each other. So thanks everybody, I really appreciate it. This has been great.